There are several reasons why a manufacturer or a firm located upwards in the economic chain may want to set or influence the price at which the good will be resold downward in the economic chain. Take a manufacturer, for instance. The manufacturer, if he's selling a branded good, may want to sustain the brand by charging relatively high prices, because then it gives the impression that the good is something which is really valuable. Or if that manufacturer wants the retailer to invest in its premises, provide, very nice environment for the products, he may ensure that the retailer makes enough profit, and the way for him to do so is to make sure that intra-brand competition is not excessive. Another possibility as well, or another kind of situation, is when you have a businessman which is very, very tempered and wants to control the whole business chain from the beginning until the end. So these are three situations where a manufacturer may want to set the price at which the products will be resold. But you can have exactly the opposite. Suppose that you have a manufacturer producing low-price goods. He may just want competition to flourish within his retailers in order to make sure that the price will be as low as possible. Or he may be willing to leave its retailers enough liberty for them to be very innovative. Or he may just decide that he doesn't want retailers to make a lot of profit because he wants all the benefits to pass on to customers, and one way to achieve this would be to have very strong intra-brand competition. So, what do we do with this? What do we do with all these situations where, depending on the context, the type of product, or the type of strategy, the manufacturers may be willing or not to fix the resale price? And I guess the question in the law, as far as the law is concerned, the question has to be dealt with in the way that lawyers systematically tend to do. And what do we do, lawyers? Whenever we have a problem that we have to solve, we systematically think of other situations where the same kind of problem may have emerged, because we want to ensure that the solutions we are giving to a problem will be consistent with other solutions. And so, when they have been asked to think about the legality of resale price maintenance, lawyers have thought of what they had decided in this other situation where prices were fixed. That is, a situation where retailers horizontally would agree with one another to set prices, a situation which amounts to a horizontal price fixing agreement, and which, under the jurisprudence, unanimously is criticized as being illegal per se. They've used that model in order to analyze resale price maintenance, meaning that they have considered that resale price maintenance could be a way for retailers to arrive to the same situation where they stop competing on prices against one another through the intervention of the manufacturer, giving them instructions to all charge the same price. There's a very good example of this in the European Union back in 2001, so a relatively recent case, Volkswagen, where, as you all know, this manufacturer selling very nice cars, this manufacturer is selling very nice cars through a lot of distributors. And in that case, one of the distributors was trying to promote one of the models, the new Passat, in fact, through charging a very low price for that model. And so, almost immediately, the neighboring shop sent a message to the manufacturer saying, I quote, "Should we accept this? This is for information what this shop is doing. Greetings, signature." The result of that message was that 15 days afterwards, 15 days later, that distributor, which was making that very special promotion, undercutting the prices at which the product was being sold, received a letter from the manufacturer stating, please stop doing this. Charge the same price as your fellow distributors, fellow colleagues. The case, of course, was decided by the European Commission. The European Commission decided that this was a way to charge, to fix prices, in fact, something which is absolutely illegal under European competition law. This has been generalized in the regulation that was adopted in the European Union concerning vertical restrictions, where you can find the following language. The exemption, which is normally possible for vertical restrictions, shall not apply to vertical agreements which have as their object the restriction of the buyer's ability to determine its sale price. That's the solution for the European Union, but you can find just about everywhere in the world the same kind of solution being brought to this difficulty, particularly in the United States, for instance. Already back to 1911, you had this famous Dr. Mize case featuring a manufacturer of proprietary medicines trying to set the price at which these medicines would be sold afterwards, downwards in the economic chain, and ousting the defendant, which was actually a wholesale drug concern and which had undercut the prices at which these products normally would have to be sold. And so the case arrived to the Supreme Court of the United States, which decided that indeed this is just about the same thing as a horizontal price agreement. And the Supreme Court said the manufacturer can fare no better with its plan of identical contracts than could the dealers themselves if they formed a combination and endeavored to achieve the same result by agreement with each other. So the lesson is resale price maintenance, at this stage at least, has been considered, at this stage of this intervention, has been considered something illegal after the model set by horizontal price agreements. So that standard of resale price maintenance being considered illegal per se has remained in force for a relatively long period. But pretty soon there have been hesitations as to whether it was really the nicest, the best solution, because there was this question: are there situations where maybe resale price maintenance could be pro-competitive? In other words, where RPM could provide benefits to society. Just give you one example. Binon, back in 1983, concerning newspaper publishers selling the newspapers through retail outlets and stating the price at which these newspapers would have to be resold by the outlets. When the case arrived before the Court of Justice through a national court, the Commission, European Commission, which was providing observations in the case, stated, well, that's resale price maintenance. And according to the law, RPM is illegal per object. As a result, should be prohibited. But then before the court arrived the German government. And the German government stated, well, in fact, these newspaper publishers need to be charging or setting the price at which the newspaper will be resold, because this limits intra-brand competition among the outlets and ensure that sufficient profit is made by the retailers, as a result ensuring pluralism on the market, pluralism in the number of newspapers that are available. So they were saying, the German government were saying, RPM constitutes the sole method by which a wide selection of newspapers and periodicals can be made available to readers. That's one of the reasons given by the German government. And the government also provided another reason to justify RPM in that context, saying that higher profits would be possible through RPM, not only for retailers, but also for publishers, thereby making sure that the publishers have enough revenues, allowing them to take back afterwards all the unsold copies remaining in those outlets. That's loss, basically. That's wasted paper, wasted newspapers, and in order to cover the losses coming from these unsold newspapers, they have to realize enough profit, and that's possible through RPM. Government was saying the fixing of the retail price by publishers constitutes the sole means of supporting the financial burden resulting from the taking back of unsold copies. That's for the European Union. The same kind of pattern appeared and developed even further in the United States. I have another case to mention maybe. Valet Liqueurs versus Renfield Importers, Court of Appeal of the Second Circuit Federal Court. In that case, you had a manufacturer of wine and liqueur selling its products through distributors. One of them, Valet Liqueurs, undercutting the prices and being, as a result, ousted from the system because it was enraging, actually, the other distributors who were not making any more sufficient profit. And the case arrived before the court, before Judge Postner, who was sitting in the court. And that judge said, well, maybe RPM in some instances is negative for competition, but maybe it can have advantages as well. And what kind of advantages could that be? For instance, fostering, in the absence of price competition, fostering non-price competition. The service, for instance, which is provided to drinkers, to clients who want to know what kind of drink they would need to have for an evening in solitude with someone that they love, or in order to receive, to invite someone professionally in this kind of different situations. And so the judge said, the elimination of a price cutter who is taking a free ride on the promotional efforts of competing distributors will tend to stimulate non-price competition among the distributors, so that the net effect on intra-brand competition need not be negative. And the consequence, the judge said, is that, according to him, we should do away with the per se illegality standard and create situations where we can examine pro-competitive and anti-competitive effects, that is, in fact, applying the rule of reason. Paragraph 9 of the judgment, the plaintiff must show that the restriction was unreasonable because weighting effects on both intra-brand and inter-brand competition, it made consumers worse off. So these hesitations became so intense that progressively the standard of per se illegality of resale price maintenance was overruled. This happened particularly in one case of the Supreme Court of the United States in 2007, the famous Legion case, featuring one manufacturer of leather goods and accessories, particularly belts, under a specific brand, selling all these products in shops that they wanted to be of a very specific sort, that is, shops investing in, as they said, superb services for customers, because they had the feeling that consumers, as a result of the existence of these mega stores, were completely confused about the kind of product that they wanted to purchase, and that they needed superb service in order for them to make choices. So here we are, Legion Creative Leather Products is distributing its leather goods and accessories in all sorts of retail shops, but one of them, again, Case Closet, is undercutting the prices by 20%, thereby making absolutely ineffective in the region concerned, making absolutely ineffective the efforts made by the producer, because the clients basically were going to the retail outlets providing service in order to receive information, advice, and then were returning to Case Closet in order to purchase the products. And so there was a disagreement between the two firms, and the case arrived before the Supreme Court of the United States, which had to decide on this basis and took into account the fact that they were pro-competitive as much as anti-competitive reasons, effects on the market, and on that basis decided that the per se illegality standard would have to be overruled and replaced by the rule of reason, a standard where there is a detailed examination of pro and anti-competitive effects. How about the other jurisdictions? Well, some of them are tempted to adopt the same kind of standard as in the United States. Others are resisting, making it very difficult nowadays to predict whether or not resale price maintenance will be accepted or not. Maybe we can turn to the European Union to have a slightly different rule being set by the European Commission, and something which may look as a compromise between the persons or the scholars considering that RPM should almost always be accepted, and others considering that it's bad. So, as a reminder, in the EU regulation on vertical restrictions, there is this idea that normally you cannot have an exemption if you have RPM in an agreement. This means, as explained in the guidelines for vertical restrictions by the Commission, it means that where an agreement includes RPM, that agreement is presumed to restrict competition. So prima facie, the fact of having RPM in an agreement implies that normally that agreement should be deemed illegal. But, the guidelines say, but undertakings have the possibility to plead an efficiency defense. Meaning, even if they cannot benefit from a systematic exemption, they can try to put forward arguments tending to show that there are indeed pro-competitive arguments, pro-competitive effects to RPM. This places us before a situation where most of the time officials, judges, undertakings will have to think about the effect of RPM clauses that they may include in their agreement, try to see whether they are pro-competitive arguments and anti-competitive arguments. And let me give you a few examples of pro-competitive arguments. Some things that they may try to take into account is to what extent does a limitation of intra-brand competition through RPM first stimulate inter-brand competition, meaning if all retailers for a certain brand charge the same price for that brand, is that going to increase the competition which exists with other brands, with and distributors selling other kinds of products. Second, to what extent does RPM encourage retailers to invest in services or promotional efforts? Because they're less involved in intra-brand competition with retailers selling the same good. Maybe those retailers are going to invest through, because they have higher profits, are going to invest in selling that brand. And that's going to be beneficial to customers as well. 3, does RPM prevent discounters from free riding on retailers providing services? In other words, are we in a situation where RPM prevents some outlets to selling at very low prices because they are counting on others to provide information and service for the same product? And 4, is RPM facilitating market entry? Indeed, if you have RPM, it means that as a retailers, you would make a certain level of profit and benefit as soon as you arrive on the market, thereby making it more palatable to enter the market. That's for the pro-competitive arguments, but you may also have anti-competitive arguments. Let me give you 4 examples, 4 questions that we may ask. Does RPM contribute to price increases because retailers are not anymore competing against one another for the sale of a given product, a given brand? Does this translate into a price increase for that brand, to a price increase which is unacceptable? Second question, does it lower the pressure on margins made by manufacturers? Because if you have RPM and limited intra-brand competition, this may allow the manufacturer, particularly when inter-brand competition is not particularly vivid, this may allow manufacturers to make a higher profit. And to what extent is this compatible with the willingness to provide customers with enough benefits? Third question, does RPM facilitate collusion among manufacturers? If all retailers of a specific brand charge for that brand the same price, the market is becoming very, very transparent, thereby making it possible for manufacturers to observe one another, to observe the conditions under which their products are being sold, and as a result, possibly to organize a form of convergence between these prices or among these prices, which would amount to collusion, which is not really appropriate for customers. And last question, does RPM allow powerful manufacturers or retailers to abuse that situation, particularly through prices that are not acceptable or through all kinds of clauses which would not be to the benefit of customers? So we have arrived to the conclusion of this very small examination of resale price maintenance. Let me remind you what we have been doing. First, we have seen that there are all sorts of reasons why manufacturers may want to resort to RPM or may not want to resort to RPM, all this depending on context, strategies, products, and so on. Second step, we've seen that lawyers, thinking in terms of consistency, have applied to RPM the standard that they were using for horizontal price agreements and have declared RPM illegal per se in the US or per object in the EU. And then in the third step, we've seen that even though there was this standard, judges and authorities and scholars started to think and to realize that in some instances, maybe there are pro-competitive advantages to RPM, and they have started to criticize, undermine the standard of per se illegality. This culminating into four-step Legion, where the standard was overruled in the United States by the Supreme Court of Justice, and in the EU, in the guidelines where, even though the Commission remains very careful and maintains the prima facie illegality of RPM, it now appears to be ready to accept the possibility of putting forward efficiency defenses when a firm is being charged with illegal RPM. We've seen at the end, that was the fifth step, what we can try to do now when we are facing this kind of clause in an agreement, that is, think in terms of pro-competitive effect, think in terms of anti-competitive effects, see to what extent the system where we are placed allow the firms to put forward defenses in order to explain that their practice, their RPM practice, is acceptable.